Assalamualaikum and a very good day. I be to Madam Hayati binti Abdul Samad and fellow classmates. My name is Muhammad Aiman Arif bin Muhammad Kamil with the matric number of 264613, and today our group will be presenting to all of you the case analysis of Foss against Harbottle in 1843. Without further ado, I shall begin our presentation by stating the facts and judgment of the case. Victoria Park Company was established in 1835 in relation to the acquisition of 180 acres of a piece of land near Manchester. 2 years later, an act was passed by the Parliament to which the company was incorporated for the purpose of laying out and maintaining ornamental park within the township of Rusholme, Charlton Medlock and Moss Side in the county of Lancaster. In this case, the plaintiffs were Richard Foss and Edward Starkey Turton, were the two minority shareholders in the company. According to them, the property of the company was misappropriated and wasted and had caused various mortgages which were given improperly over the property of the company. Both shareholders then decided to take a legal action on behalf of themselves and also other shareholders or proprietors of shares in the company. Therefore, they filed a claim against 5 directors, architects, and assignees, which causes them to bankrupt. Their claim was based on the following grounds. First, the fraudulent transaction under the assets of the company were misappropriated. Number 2, the insufficiency of qualified directors in the company who can actually make up the board. And third, the company had no clerk or office. Due to these circumstances, the shareholders had no power by which they could take the property from the hands of directors and therefore had to commence legal action against them. The judgment of the case. In this case, Sir James Wigram dismissed the claim of the shareholders and held that an individual shareholder or any outsider of the company cannot take any legal action against the wrong done to the corporation, as both company and its shareholders are considered as the separate legal entities. According to Section 21 subsection 1A of the Companies Act 2006 of the United Kingdom, a company may sue and be sued in its own name, and a member may not take any legal action on behalf of the company. And if a company has a right against the party under a contract, then it is for the company to sue. The reason that shareholders for the company cannot sue is that the company is the one who has actually suffered the injury and not its members. So it is not on the company to sue or take illegal action against those members who have misappropriated its property. His Lordship followed the judgment passed in all the cases on the unincorporated companies and insisted the minorities to show that they have exhausted all possibilities of redressal within the internal forum, as he has stated that the courts will not intervene in those cases where majority of the shareholders can ratify the irregular conducts. However, this rule was considered as unfavorable for the minorities because it barred them from taking any legal action whenever the alleged misconduct was in law capable of being ratified. Therefore, 2 principles were established by the court, which are the proper plaintiff rule and majority principle rule. These 2 rules will then be explained further by my fellow groupmates. Unfortunately, the application of these principles appeared to be very harsh and unjust for the minority shareholders, as although a substantive right have been provided to them, they were still barred from obtaining justice under the rule and have to submit to the wrongs done by the majority, as they were the ones who controls the company, while minority members have no say due to their small strength. Therefore, in order to mitigate this harshness, the court then further developed 4 exceptions to the general principle, which are the ultra vires and illegality, actions require a special majority, invasion of individual rights, and frauds on the minority. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Zafri bin Sharif and my ID number is 265362. Today I would like to explain about the first rule, which is derived from the case of Foss against Harbottle. The first rule is called the right plaintiff rule, or also can be called the proper plaintiff rule. The proper plaintiff rule set forth in the case of Foss against Harbottle is the parent of the wrongdoer control prerequisite to bringing derivative litigation at common law. It provides that only the company itself can bring litigation for the infringement of obligation owed to it, and only if the company is disabled from acting, such as where there is wrongdoer control of the general meeting. Will the law countenance a derivative action? If it is not so disabled, the proper plaintiff rule provides that a derivative action cannot be brought. The wrongdoer control requirement is not, as it is sometimes presented, a procedural appendage to the proper plaintiff rule. In the proper plaintiff rule, in respect of wrong committed against a company, is the company itself and not the shareholder. In such a scenario, if you feel that the directors or majority shareholders are doing something wrong, they are committing the wrong against the company and not against the person personally. Therefore, the entity which has the right to take any action is the company and not you. Proper plaintiff rule also means that if company suffers any loss due to negligent or fraudulent acts of directors or outsiders that do not want to pay the debts due to the company, only the company itself can sue the directors or the outsiders to enforce the company rights. Individual shareholder cannot sue for wrongs done to company or complain any internal irregularities. If a director has breached his duty, it is for the company to enforce its corporate right. A member of the company has no locus standi and therefore no cause of action since the injury or harm or loss complained of has been suffered by the company. The company is therefore the proper plaintiff to commence an action. This principle is derived from the case of Foss against Harbottle. Rules of Foss against Harbottle has established an elementary principle in the field of company law. The proper plaintiff for a wrong done to a company is the company itself. This principle, together with the Solomon principle of separate legal personality of companies, have been of invaluable importance for commerce and modern economy. On the flip side of the coin, have always lain the minorities commonly protected by derivative claims and unfair prejudice remedies. After the entering into force of the new statutory derivative actions, many scholars argued that the rule of force was abolished. Also that there would be an increase in shareholders' litigation and have further expressed concern about overlaps between both derivative actions and unfair prejudice remedies. Thank you.
Hi, my name is Mama Amin. My metric number is 261429. And today I will explain about the criticism to rule of the right of proper plaintiff. This rule of proper plaintiff is established in the case of Foss and Harbottle. In this case, a minority shareholder, on behalf of the company, has alleged the wrongdoing of the right director of the company. However, the court held in this case that individual member cannot bring any action in this way as they had suffered no loss and also they had no local standi. From the case, the principle is derived is where when the damage done to the company, it is the company that should make the claim. This rule in this case, except Foss, has become the parent principle of the wrongdoer control prerequisite to bring a derivative action. However, the rule that be said in this case is to be too restrictive, and there are also some place of the rule that seem to be unclear. First, we can see from the rule that it provides that the member of the company cannot sue on behalf of the company to enforce the company right, as company is a separate legal entity, meaning that as the company that suffered damage, only the company that can make the claim if followed by the rule. And also from the rule, an individual can only bring an action to wrongdoer on behalf of the company only if after that individual been authorized by the board of director, or that individual has been passed by ordinary resolution through the general meeting. By this rule, we can see that it will prevent that the aggrieved minority shareholder from pursuing any action relation to the wrong done by the wrongdoer. Moreover, when we look to the rule, as it can be manipulated to the detriment of the company as a whole, this rule can be said to generate unequal or unsatisfactory result. That because there is a risk that the company will not take any action because no one take action on its behalf, especially during the period when the wrongdoer is the one that in control of the company. In a situation where the wrongdoer are in control, of course, generally, they will not take any action on the company behalf against themselves. This will put the members of the company, particularly the minority, at the advantage. Which is why during the development of this rule, we can see that the law commissioner has put effort in the fixing the flaw of this rule. We can see that there is the exception made throughout the process to this rule, and also in the end, the legislation also had enact a statutory derivative action. This rule in Malaysia context, luckily, our country has stepped in line with other jurisdiction to enact its own statutory derivative law, which set out in the Company Acts. We can see in section 3473, it gives right to any person to bring or to intervene in defend or discontinue any proceeding on behalf of the company at the common law is abrogated. The word abrogated is mean naturally that the litigant will only live with the statutory derivative action, which is repeal the proper plaintiff rule. Also, in section 121 of the Act also had authorized the minority shareholder to take the company names in order to take action against the company wrongdoing. This is to seek the condition of where the director under majority control or when the situation there is no majority shareholder did not take any action for the company wrongdoing. We can look that is if our country follow the rule of in Foss and Harbottle, it surely will prevent the aggrieved minority shareholder to take any action against the wrongdoing done that damage the company properties. That's all from me. Thank you.
Assalamualaikum and a very good day. My name is Muhammad Al-Hazim bin Idris, metric number 264662. Today I'm going to talk about the principle of majority rule as applied in the case of Foss and Harbottle. In this case, the court held that as the shareholder can convene a general meeting to bring the case of alleged misappropriation of the company's property against the defendant, in such circumstances, there was nothing to prevent the company from obtaining a redress in its corporate character to its majority shareholder, hence dismissing the claim brought by the plaintiff as it was not for the minority shareholder to bring such cases. In essence, the instant judgment laid out the rule that any decision or action undertaken by the majority shareholder is binding and shall be respected by all members of the company and by the company itself. And if an alleged wrong or irregularities due to such decision or action can be lawfully solved, authorized, rectified by a simple majority of members in a general meeting, then the court will not intervene in those cases. Among the justification for the application of this principle is that shareholders are supposedly more appropriate party to determine the internal affairs or dispute of the company. It would be futile and unnecessary to give recourse to the court for an issue that a company can easily solve on its own or a wrongdoing that can be settled within its own internal procedures. Without this principle, there would be multiple superficial or vexatious litigation by the dissatisfied minority shareholder, and in turn, this would compromise the normal performance and function of a company. However, there should be a balance between efficient governance of a company and the shareholder interest. Secondly, the will of the majority shall prevail. A shareholder of a company agrees to submit to the will of the majority upon becoming its members. This notion stems from the fact that it would be impractical to obtain unanimous consent from every member for every corporate decision. Thus, similar to the concept of democracy, the majority shall exercise the powers of the company and determine its affairs. This principle is also recognized and upheld in many Malaysian cases, among others in Hare So Kong Mil and Lim Beng Soon. The court held that the mere fact that those managing the company possesses a majority of the voting powers and in reliance of that powers make policy or executive decision with which the complainant does not agree is not sufficient. Those who take interest in the companies limited by shares must accept the majority rule. In conclusion, the action brought by the plaintiff failed as it was not acted or authorized by the majority shareholder of the company. Thus, it is contravening with the principle of majority rule. It is only to the majority can an action be brought against any wrong done to the company.
Assalamualaikum warahmatullahi wabarakatuh and good day. My name is Muhammad Zulkarnain Abiwan Asmira. My metric number is 263281. Who are you? Are you in the majority group or in the minority group? If you put the majority against the minority, what would be the result of it? I believe that the result is very obvious as we are living in this democratic country. The majority will always win against the minority. But is that it? Do we have to let this keep going on? If we keep following this rule blindly, the majority rule, the majority will always win against the minority no matter what. Or do we have to look at the circumstances before applying this rule? In this Foss and Harbottle rule, the majority rule to be specific, it is undeniable how this case has highlighted the principle of the majority rule, especially among the shareholders, just like how it has been discussed just now. This rule can be criticized in a manner on how it managed to prioritize the majority compared to the minority. This is because the decisions, opinions, or positions of the majority will always prevail against the minority. In this discussion, the issue that will come into mind is what rights the minority will be left, or what are the things the minority can do in order to prevail the justice in the company, as the rule has somehow made the minority left in an unprotected position. In this rule, the rights and powers of an individual within the company will be decided upon their amount of shareholding in the company. In other words, this rule will give the majority shareholders in a company to make any decisions. After the decisions has been made by the majority shareholders, the minority shareholders are required to accept it, as the majority shareholders are holding a greater power and a greater rights compared to the minority in a company. So, does the minority shareholders have the voting right? Yes, but if you are not the minority, if you are not the majority or the substantial shareholders, then there is every chance that you may be outvoted on a matter that may be crucial to you. So what if you feel that the directors or the majority shareholders are doing any wrong? Can we take the action? So as have been discussed, and from the rule of this Foss and Harbottle, which is the majority rule, the general answer will be no. Because in this particular case, it does not provide the rights to the minority members who complain about the wrong done to the company, as the majority shareholders decided to not take any action for that particular wrong done. The application is very strict and very harsh and unjust with regard to the minority shareholders. This is because although the substantive right has been given to the minority shareholders couldn't obtain justice under the rule and have to submit the wrong done by the majority, because at the end of the day, it is the majority of the members who have the final decision, who have the final say about any decisions that are going to be made in the company. As the minority members have no say due to their small strength of number, as how it was portrayed in this Foss and Harbottle case. It is in our own opinion that we believe that everyone should have the right to be heard. Same goes to the right of to give opinions and to a fair hearing. But what if it is happening in the company? Specifically, the principle of the majority rule for sure will not allow such right to be happen, as it will put a boundary or wall for the minority to be heard, as they are holding lesser power compared to the majority. Thus, the action of the UK government and also the Malaysian government in creating exceptions for this principle, specifically to support the minority and to avoid any prejudices, should be applauded. The exceptions can be seen in the Section 994 of the Company Act 2006 for the UK and Section 181 of the Companies Act 1965 for Malaysia. Thank you.